Hello class, this is Dr. Fenton. In this chapter we'll talk about evidence that you'll be collecting that hopefully will be presented to the court. So let's get started. Okay, so Chapter 9, Proper Evidence Management. Now this chapter explains the basic rules of evidence, examines basic evidence issues that can affect accountants when performing litigation services, and it goes on to say you need to make sure that the evidence is retaining its integrity and that it will not be thrown out and can be admitted into the court. Okay. All right, next page. What are the rules of evidence? Well, there are rules in the federal court system, federal rules of evidence, that will explain about evidence, what can be admitted, what has to be left out, and so forth. But first of all, let's talk about what is evidence. So you can see down here in the green, and you probably already know this, but evidence is testimony, writings, and material objects offered to prove an alleged fact or proposition. Now, a couple of different kinds of evidence. There's direct evidence. That evidence, whatever it is itself, directly proves a fact at issue without the need for any inference or presumption. Here's the evidence. It proves a fact. Okay? Now, circumstantial evidence. And you probably heard this word on TV and so forth. You might think, oh, well, circumstantial evidence, that's sort of secondary evidence, and it may or may not be reliable and so forth. Well, it is used. And as you know, that circumstantial evidence is evidence from which a fact at issue may be proved indirectly. Okay? So let's look at the green down here to sort of explain that. Let's say that during the night it rains. It rains around your house. If you wake up during the night and see it raining, that's direct evidence. You see that fact that it's raining, that proves it. However, if you sleep during the night and only observe your wet yard the next morning, that is circumstantial evidence. You see the wet yard, the wet sidewalks, the wet street. So you're inferring it must have rained during the night. Okay? So that's the difference between direct and indirect. I saw it myself, or I saw the result of the action. And circumstantial evidence can be just as powerful in the courtroom as direct evidence. So don't think it's a second class of evidence. Now, yes, direct evidence is always good to have, but circumstantial evidence is also very good. Let's see what we have here. Now, you might have some kind of evidence, a document or whatever, but the thing is it admissible in court? Can it be used, relied upon? Is it admissible? Well, it can be. For it to be admissible, the first step is it must be a specific factual foundation that's required for that evidence. Okay? And then to be admissible in the court, it must be relevant. Now the judge will decide whether it's relevant or not. Your side might be offering evidence. The other side might object to that, and the judge has to make a ruling. Will we allow this evidence to be presented in the courtroom? You've probably seen those court shows on TV, and that's what they're doing. They're trying to get thrown out. But the other side might say it's not relevant. You're saying it is relevant. Please let it stay in the proceedings. Now, it might be good evidence. It might be relevant. But it may be inadmissible in court if its probative value is substantially outweighed by the danger. It will unfairly prejudice a litigant and mislead the jury, in other words. So, yes, it's relevant, but it's going to give maybe a false impression, mislead the jury, and so the judge decides to leave it out. And down here, evidence of habit. Again, you're reading this yourself. You can read about inflammatory evidence and so forth. Evidence of habit, because you might use this itself, because if you can look at the accounting records, maybe look at canceled checks, and see that a certain person in the company always signs almost every check, that's a habit, right? Evidence of habit. And then you might be relying your evidence on maybe fraud or whatever, that you found a check that was signed by someone else. Maybe the party that's being accused of committing fraud. So there's your evidence of habit. Usually this one person signs the checks, but here's the exception. And that exception might relate to the accused. Exclusionary rules. Now, evidence might be kept out, not allowed, because it might hurt one party or the other unjustly if it's entered. So if the parties before trial had been trying to negotiate a settlement, and one person maybe had pleaded guilty or a certain amount was offered to settle, then that cannot be admitted as evidence. One party might try to use that and say, well, look, the other person may be was going to admit in a settlement that we cannot agree to. That cannot be allowed. So that's an exclusionary rule. Privileged communications. As an accountant, you have to be careful here. You have to understand where there is privilege, and there's not a lot for accountants, at least not the type of privilege we're talking about for attorney-client privilege. So you can see there are certain protected communications: attorney-client, doctor-patient, priest-penitent. You don't hardly see that accountant-client privileged communication being brought up. Sometimes it's there, sometimes it's not. It might determine where you live, what jurisdiction you're in, which state, and so forth. So if you're concerned about this, I guess you should be, talk to the attorney you're working for and find out if there's any privilege, like the documents you're working on, communications you have with the attorney or the attorney's client, is that privileged or not, right? So you need to make sure what's privileged for the work you're doing in here. So I'll let you read through this. And just talked about this. Accountants, unlike attorneys, have no accountant-client privilege under the federal state common laws. So it usually does not exist. Some states have recognized an accountant-client privilege, but that's very limited. So don't count on that, right? Attorney-client privileged, it's just almost always there. I mean, probably 99.9% of the time. You talk to your attorney, that should be privileged. You talk to your accountant, that probably will not be. Any work performed by accountants for the attorney, upon the attorney's request, could fall under the attorney-client privilege. I think it would have more of a tendency to do so if the forensic accountant is working as a consultant, we talked about earlier, as opposed to an expert witness. Maybe some expert witness work might be able to fall under the attorney-client privilege, because remember, you're working for the attorney. You're not working for the client. So the attorney might be able to keep that under the attorney-client privilege and not be exposed for the other party to subpoena. But again, be very careful about this. As the accountant doing the work, I would always assume all my work could be seen by the other party. They could subpoena it, and the judge says, okay, yes, give the other side your working papers. So just be careful. Must draft copies be saved? It seemed like in the past the answer was yes. Now though, you're doing a lot of work on the computer. You rewrite a letter, you rewrite the spreadsheet. Well, that destroys the previous version, right? It might not be able to be recovered. It overwrites it. So if this is concerned, you can talk about this with the attorney you're working for to find out if you have to keep every single draft of anything you make, or just the final draft, right? That's finally used in the report or whatever. So again, make sure you read through this. There are some new rules, fairly new rules, that extend the work product privilege to certain communications between the testifying expert witness, you the accountant, and the retaining attorney. So Rule 26 and B4A and B now protect drafts of any reports or disclosures required, regardless of the form in which the draft is recorded, and it further protects communication between the party's attorney and any witness required to prepare a report, regardless of the form of communication. There are 3 exceptions to this rule. So there's always almost an exception to everything in the law, so be careful. there is some protection there. This is a legal matter. Talk to the accountant you're working for. Make sure you understand at what point does your work become exposed to the other side. Up to that point, it might be protected, and then past that point, it might be available to the other side in the court case. You can read about the medical privilege, spouse privilege, and so forth. Hearsay. I'm sure you've heard of this term, hearsay. Is hearsay allowed in the court as evidence? The general rule says no, because they're considered untrustworthy, but there are many exceptions where hearsay is brought in as evidence. So let's look at this. Here are some exceptions to the rule. You can look at this. Effective listener, they look at all this. And then when hearsay is admitted to evidence, it's often through one or more of the exceptions. And there are three concepts: trustworthiness, the unavailability of the declarant. The declarant is the one that made the statement, and then someone else heard it. That's the hearsay. So that person in the middle might be the witness, and that hearsay, I heard John Doe say something. John Doe's not around anymore to testify. That hearsay may be allowed, so that second person may be allowed to go to the courtroom and say, I heard John Doe say this. It's hearsay. But again, you have to follow these rules, and there is a practical consideration on this. Now, there are some types of statements traditionally accepted from the hearsay rule as not being hearsay. So you might consider something, well, that should have been hearsay, but these rules here, again, look at this, this say, well, no, this is not hearsay itself. Business records, for example. You can look through here, commercial publications and so forth, statements, look down through here. A dying declaration, read through this, this is interesting. And now let's jump to authentication requirement. Now, any evidence you're working with, you want that evidence to be admitted into the court. Because if that evidence is not admitted, your opinion, your work based on the evidence, that part of the work is thrown out. That could hurt your work. So to be admitted as possible evidence in legal proceeding, a document or other material must usually be authenticated or identified as what its proponent claims it to be. And this says that great latitude is allowed parties in authenticating evidence. And let's see. Showing that the process by which the computer records were prepared was accurate may serve as adequate authentication. So you have computer records maybe printed out, but if you can show that here's how they were prepared, that might be authenticated, right? And then there are certain materials exempted from the authentication requirement: public documents, certified copies of records, newspapers, periodicals, business information, control and origin, so forth. Best evidence rule. Okay, the best evidence rule historically required that the original documents be produced rather than secondary evidence, including oral testimony. Yes, you would like to have those original documents, but it does say if they're destroyed or lost, maybe that secondary evidence, like a copy, can be presented. Now, demonstrative evidence is just a chart prepared that maybe summarizes other evidence. So it can be a chart, a diagram, photograph, video, a model, or so forth. These may or may not be allowed. It's up to the judge. Talk to your attorney. See if your attorney wants to prepare one of these for presentation. But the judge can always toss this out. So, again, does it assist the fact finder? If the judge thinks so, it'll be admitted. Let's see, I'll let you read through this. Administrative proceedings. This is an alternate way to have an issue settled. It might go to administrative proceedings rather than the real courtroom itself. Now you want to maximize client confidentiality. So you want to read through this. Protecting the work. The attorney should retain the consultant. Yes. Remember, you as the accountant, you're hired by the attorney, whether you're a consultant or the expert, right? You're hired by the attorney, not the plaintiff or the defendant directly. The expert should obtain facts through or at the direction of the attorney. The investigation should be done at the direction of the attorney. So again, your client is the attorney. Any documents you want, any procedures you're going to do, you need to clear it with the attorney. Not that the attorney is going to direct you what to do. You have to make sure that it goes to the attorney to make sure it's protected if protection is sought after and is to be retained. Whoops. Sorry about that. Okay. And the attorney should be present when the consultant meets with the client. So remember, you got three parties here. You have the defendant or the plaintiff, that's the client. You have the attorney, the plaintiff or defendant, that client hired the attorney. Now the attorney has hired you. Okay? So three people here. Let's see what's next. Now, this gets into gathering evidence. You're trying to gather evidence. You're trying to find records, documentation to support, your conclusion. And so how should you try to go find that evidence, right? This Benford law is a very interesting area. There are articles written about this, and this is like a small paragraph. But a person named Frank Benford, back in the 1930s, discovered that on numerous forms of data, just out and about, not just accounting documents, any kind of data, there's usually a certain pattern on when that first digit that's in that number is a number 1 or number 2 or 3 or whatever. So through this work, this person found out that 30.1% of the time, whatever number you're working at, looking at, it can be check amounts, check numbers, invoice numbers. It could be street addresses. Whatever number you're looking at, 31.1% of the time, that number starts with a 1. That's how you read this chart. A number will start with a number 2, 17.6% of the time, a big drop. And you can see how it drops off here. And so only 4.6% of the time, whatever number you're looking at will start with a 9. They even get into the second and third digit. So I'll jump to the third digit. This means that when you have a number, let's say it's in the thousands or whatever, the third digit in that number will start with the number 1, 10.1% of the time. It'll be a 0, 10.2% of the time. Look how more evenly this is. And this is somewhat even. This is a drastic drop here. So very interesting area. This has been used by agencies like tax authorities to do research on the records, find anomalies, something unusual with the pattern of these numbers, and they find out, oh, there was tax fraud involved. So very, very interesting area. And I want you to read through this. You can find out when it's useful or not useful. And now the next couple pages gets into data collection with computers. There are data mining tools and so forth. I want you to be careful down here. When you get to the point, you have to go into computer records yourself to find data, like in a fraud case. If you're not an expert witness, if you're not a computer forensic expert yourself, hire one of those people to do the work for you. You have to be very careful about the evidence. You're trying to gather evidence. If you destroy that evidence by just opening a file, it might not be able to be used in court. So be very careful in this area. When you want to search a hard drive in a computer, get the computer experts to bring in there, mirror the hard drive with software tools that are allowable to be presented in court. You make a mirror copy of that hard drive. then you search the mirror copy. You never search the original copy of the hard drive. That destroys the evidence. So before you get into all of a sudden using these data extraction tools like IDEA or ACL, you need to be working on the copy, not the original data. So be very, very careful about that. Again, you're trying to collect evidence you're going to use like in a fraud case or another report, and you want that evidence to be valid, be relevant, and be admissible in court. What do we have here? Read through that. Computer evidence, again, computer forensics, a big area. You want to protect the data. So if a computer that you want to search is connected to an outside line, with a telephone line back in the old days, or a wireless system, a cable is connected, you want to video and photograph all the connections in that computer. You don't turn that computer on. You get the forensic expert, the computer forensic expert, to come in and decide how to handle this. If you turn a computer on and the computer belongs to the suspect, that suspect might have a program in there that if you don't type in that password that only that person knows, it could destroy everything on that computer. So you got to be very, very careful. So again, read through here, get the computer experts involved if you're not an expert yourself. So documenting talks about this, evidence log, chain of custody is very important. That's all we're talking about here. You want to ensure admissibility of the evidence you're collecting admissible into court. So you don't want to destroy it. Whether it's computer form or actual documents, you don't want to destroy it. You need to safeguard the evidence. You need to safeguard your working papers. Keep everything locked up. This is for evaluating the persuasiveness of the evidence. It must be relevant. We talked about this. Objective, documented. Third-party evidence is better. Large samples are better than small samples, and so forth. Okay, let's see. Did I highlight anything else? Oh, record retention. Yes. Again, you're worried about chain of custody, and you probably have seen that on the TV court cases. The chain of custody with the murder weapon or whatever. Okay, you have to make sure once you identify evidence, you can account for where it has been for every second until it's presented to court. Talk about chain of custody. Just mentioned that. So those CSI shows, they talk about chain of evidence all the time, even financial chain of evidence. There's a custody form. And there's the conclusion. So that's it for this chapter. So as always, good luck with your studies.